As a court, please.
Yes,
I'm intending to draw to the conclusion of my argument, because in the debate I've covered much of what I would have covered sequentially in my address to the court. There's just one case that I had intended to refer to the court in respect of the functions of the public protector, and that's I referred to the certification judgment and the mail and guardian judgment that the functions are investigative, and this court in the Competition Commission of South Africa versus Telkom, SA Limited and another, 2010, Volume 2, All SA 433 SCA, said at paragraph 10 and 11, and this is in respect of the order crowd principle and whether it's applicable, that where one is dealing with investigative functions, those are not functions of an administrative nature and they don't have the capacity to affect legal rights. And in that sense, other than the principle put to me by Justice Nafsa that there is a broader principle than just what is in order.
Go back to Hanukkah and Volfrius.
Yes, but in respect of order, the submission I want to make by reference to this case is simply that the functions of the public protector would not meet the two requirements for administrative action, which is that it must be functions of an administrative nature and have external legal effect, capacity to affect rights.
But I didn't understand you to suggest that if she came to a conclusion, she couldn't be challenged in a court.
She could be challenged.
She could be.
Yes. That's what the mail and guardian says on a legality principle.
No,
could be challenged.
Yeah.
We accept that. The only other proposition we make is the rationality point, which I debated with the court. Then that brings me to the order that we submit should be the appropriate order that the court can give. And in the main, we ask for the appeal to be upheld and for the High Court order to be set aside. But in the alternative, and this is in light of also of the questions put to me in respect of the holding suspension under paragraph 2 of the notice of motion, we would submit that the proper order would be to, if the court upheld the appeal but wanted to change the order of the court below, would be to direct the SABC and the minister to consider the question of suspension, and if they were to fail to take a decision or take an unlawful decision, that would be open to challenge under review. And the reason we submit...
I didn't quite understand that. Just repeat that, please.
To refer the issue of suspension back to the SABC and the minister to consider the question whether he should be suspended. And the reason I say this is because when the decision to suspend is taken, the interests of the organization, the business interests of the organization...
You're saying the SABC and the minister will come to a very different realization to the one that they're currently owed?
Well, the court has to proceed on the basis that the public bodies will obey the law if directed by the court. There's no evidence that the minister or the SABC have previously refused to obey judgments of this court. That would be a different matter. So if the court were to say...
Could I ask you this pertinently, Mr. Manager? Because yes. I think it's important. And I want to ask you, and I want it on the record, because it's very important. Isn't it, and I'm talking about the broad public interest, and in the interest of all the parties, Mr. Arends's client apart, I'm talking about you as the broadcaster, the minister responsible for all of the amici, the public in general, the institution of the public protector, that the issues that you say that the DA came to court with in seeking Part B, be ventilated and decided conclusively, tried by a court, and one way or another somebody will be vindicated and somebody won't. Now, all I'm asking is, isn't that a win-win for the public at least, for the public interest? It's a win-win for the public interest, because the public interest will then say, well, okay, now we know Mr. Motsoeneng is a fine, upright person. Or it might say, well, they shouldn't have appointed him. But I'm just asking you that, and I want it on the record, because I genuinely want to understand why that's not the best outcome.
I accept that is the best outcome on record, Justice Nafsa. And would be in the public interest, even were the court, for example, to suspend the High Court order pending Part B. Because, and because when one considers the question of suspension, it's not only one.
I'm not sure that's technically feasible, Mr. Maniche. Let's just work it out. The DA went to court. They sought an order. You say they shouldn't have got anything at all. We're debating with you whether they got more than they should have.
Yes.
You can't give them nothing but say, let's hold it until Part B, because you don't get to Part B beyond Part 1.
Yes. I accept. The point I'm accepting, Justice Knopf, is that it would be in the public interest for all of these issues to be determined in Part B, and once and for all decided whether he was properly appointed or not appointed. The only question is, in the interim, what is to happen? Now, the public interest is one consideration, but there's another consideration, and those are the interests, the rights of Mr. Mtshweni himself, which will be advanced before you, and allied to those are the interests, the business interests of the organization. So the court would not want to put the organization in a position where financially or from a business perspective, the operations are hindered because there is a suspension put in place. And that is the only basis on which I submit that it would be...
But there was nothing in the papers that said that if he were to be suspended, the place would be leaderless and you couldn't find... I mean, that is not made out.
Well, it's not in the minister's papers, it's how he's doing in the SABC, but that's quite correct. You don't have, and that is precisely the point. The DA argues that, well, we complain about the fact that a fair suspension hearing hasn't been conducted. And they say, but you had it before the High Court. The reason why you don't have those considerations fully canvassed before the High Court is because the High Court was not a suspension hearing, which is what is contemplated under the law. Because
it's still a good book, I understand, that the old Jones and Buckle and the test for interim interdicts.
Yes.
Balance of convenience comes in?
Well, on balance of convenience, as I submitted earlier, if the court differs with our submission in respect of paragraphs 195 and 196,
depends on that,
if the court differs with us on that there is a basis, then the balance of convenience would not favor would favor the public interest. That is suspension be put in place. But that depends on the factual findings that this court accepts on those two paragraphs.
The disciplinary proceedings also are dependent on the outcome of the review in a month's time. Because if Mr. Mtshweni and that is removed,
there's no point in holding
the
disciplinary.
Mr. Katz is still shaking his head vigorously, but let's ignore him for the moment.
Yes.
Let's just have this debate between you and us. I mean, it does seem to me, and maybe that's what they hadn't thought through, that the way that the relief was couched. As my brother Swain points out to you, if the review finds that he ought not to have been appointed in the first place, well, carried question, that's it. Everything else gets subsumed. But it could decide any one of the other issues as in his favor or against him. And you can't, I mean, what are we doing? It's almost a bit illogical to do what was done.
I accept that proposition entirely. And
the order said that the disciplinary proceedings had to be commenced within 60 days. Obviously, your appeal to that order was suspended. We're now far down the track. And you've got a review coming up in a month's time.
On the 12th of October, that's correct.
So what is the point in having an order directing disciplinary proceedings?
Yes. Well, that we accept entirely.
I'm sure you would. It's in your favor.
But all I submitted was the permutations of the orders as we submit, and the court will assess which one is appropriate.
Can I raise something with you that may not necessarily be in your favor?
Yes.
If you accept that it's in the public interest for this to be, and I think you did in response to a question from my brother Nafsa.
Yes.
If you accept that it would be in the public interest for all of these allegations to be properly ventilated, for all of the nasty business to come out in the wash, and for one to determine once and for all whether or not Mr. Mtshweni should continue to occupy this position. If you accept that, what would your difficulty be with regards to an interim suspension order pending that determination?
What is the position now? What's the position now with the suspension part? What is the position now with the suspension?
Yeah, he's still in office.
Is he still in office?
He's still in office, yes.
Could I ask you a question that's...
And the reason perhaps I can explain that is that The judgment on execution was appealed, but that appeal was, as I understand, and I'll be corrected, was put in abeyance pending this outcome.
Mr. Maniche, could I ask you a question, a factual question that perplexed me? I mean, when I read it, in all of these debates that raged, the GCEO seems to have been conspicuously absent. Now, I mean,
is there one?
Is there one? I couldn't quite understand this. One would have thought that would be,
yes.
Let's use a colloquialism, the head honcho, he would be out there. But in all of this, the GCEO just seems to have been hiding. I mean, I don't understand why it doesn't feature.
As I understand, but at the time when the proceedings were instituted in the High Court, that position was not occupied. It's now been
to somebody. There's reference to somebody who was a GCO at one stage.
There have been acting appointments in the time between that vacancy, but now there has been an appointment. But the appointment post-dates all of this affidavits being placed before.
Including the exchanges with the public protector.
During the public protector exchanges, I'll check that, but I think that was the position.
In fact, is there nothing that says Mr. Motsoeneng is the acting GCO?
They act for short periods. He also acted for a short period in that time. He's the most senior executive absent this GCO.
Okay.
Yes. There was an appointment letter with my learned friend, as you can see, he's saying something behind me that he wanted to hand up
I think he's
in
just
the High
trying
Court.
to embarrass you, Mr.
But that letter never ended up in the record because the judge said it wasn't properly introduced. But, so I've made our submissions, Justice Party and the judge.
One last thing.
Yes.
I've read about 1,000 pages, and I still don't know what Mr. Motsoeneng's highest academic qualifications.
They are in the. Some of them have been removed, I think, from the answering affidavit by the SABC, but they are post. Well,
no,
I mustn't use the.
No, I'm talking about school.
Yes.
What is the highest standard that he has attained?
So far, it would be that he's passed the NAT 9, but he's
where does one find that?
Well, I think it's explained in a roundabout way where he says what I should have completed under higher standard should have been 9 as opposed to 10.
No, I know there's a suggestion that
he's got other.
Forget about the other.
Yes.
I know there's a suggestion that and I'm not exactly clear. I mean, did he sit for the matric exam?
He tried. Well, as I understand, at the time when he was headhunted for the position, he had set for the matric exam. I don't know.
No, but I mean, why are we struggling with this? You as the employer, wouldn't you want to know that? What is the man's highest standard that he has passed at school?
Yes.
And I mean, as I say, I've read about 1,000 pages.
Yes.
And nowhere does it emerge with any measure of clarity. What was the highest standard that he had passed when he sat for his matric exam? What subjects he attempted, and whether or not he had passed any of those subjects, and what grade of pass? Well,
the reason maybe, it's not there in the detail that Justice Ponen puts to me, and the reason is that the issue shifted to just whether he misrepresented his qualifications in 1995. There wasn't much emphasis, as it were, in the dispute about what happened to him post that, as regards whatever qualifications he might have attained, how many times he tried to attain, and what he secured in his attempts. The matric, not when he applied in 1995. No, it wasn't, because he was headhunted. The people who headhunted him and appointed him make it very clear that they were aware that he didn't.
That's basically a further review, because
yes.
there are all sorts of things about advertisements, people being moved up, and
it's best for the review.
There's a concatenation there that you might not want to get involved.
I accept Justice Nafsa. That is best for the review where it's fully canvassed. If there are no further questions, those are our submissions.
Yes, thank you, Mr. Mann. Yes, Mr. Mann.
Justice Mpati, what I propose to do is to address a fundamental issue of principle which we believe would dictate the outcome of this appeal. And that fundamental issue of principle relates to the powers of the public protector. We shall do so without interrogating matters of fact that will become the subject matter of review in due course. We will do so on fundamental three considerations. The first are the provisions of the Constitution, namely Section 181 and Section 1812. Secondly, the provisions of the Public Protectors Act, because ultimately we'll seek to persuade the court that the provisions of the Public Protectors Act regulate the powers of the public protector as is contemplated by the Constitution. In other words, it is the requirement of the provisions of the Constitution that the powers of the public protector must be regulated by legislation. We submit that the legislative provision contemplated in the Constitution is the Public Protector Act.
The tail can't wag the dog, Mr. Maleka. The Constitution tells you what the foundational powers are.
Yeah.
So.
And then it says additional powers.
No. With respect, if you look at Section 181.
Anyway, you're not in the argument yet. You are
yes.
still giving us your.
And the third point that we will make is that this application pretends to be an attempt to uphold the rule of law. Far from it. It is not a design to promote the rule of law, because ultimately it was designed to take away powers which vests in other arms of government and seek to invite the court to intervene in those powers of other bodies, more particularly in this case, the national legislative arm of government, and invite the court to intrude in the exercise of those powers, even those powers were properly exercised. We understand that the philosophical basis of this court's powers of review, including interdicts, is premised on a clear understanding that the role of this court is to supervise the proper exercise and discharge of powers by public functionaries and not to take them away. You can only take them away when exceptional circumstances have been shown. Those are the fundamental three bases that we would submit. Explain the powers of the public protector. May I preface the submissions that we will make on this court by suggesting to the court that unlike our learned friends for the SABC, we submit that this court can reach the orders that have been made by the court below, fundamentally because it is in the interest of justice to do so. It does not mean that simply because the order itself formalistically is designed, asked for and granted as an interim relief, it is beyond appealability and the powers of this court on appeal. There are two fundamental cases that we rely on in order to persuade the court that you can reach the orders made in the court below, even though they purport to be interim orders. Our submission is, in the main, that those orders are not interim orders. They're final in effect. But we'll get to the point. The simple point we're making at this stage is that this court has the power, the opportunity, and the ability to reach those orders. The first is the Kumalo and Buthelezi case of the Constitutional Court. Don't remember the citation. The second is the Ota judgment, which we cite in our heads, where an interim order granted by the High Court in Pretoria was taken on appeal to the Constitutional Court, and the court reached that order on the grounds of separation of power principles.
Which one is that?
The Ota judgment, the National Treasury.
Oh, the quota.
Yes.
Ota.
Yes.
No, but perhaps we'll at cross purposes on that. I mean, perhaps when you get to that part of the argument, we can debate it.
Yes, I'll get to that point of the debate. But the point is, this is not classically an interim relief. It is an interim relief that affects vitally the exercise of public power by public functionaries, mainly for the purposes of our submission, national parliament. And to that extent, order tells us that before you take away that power, you must consider interests and considerations of separation of powers.
I think we'll debate it when we get there, but I mean, anyway.
Can I start with the first consideration, and that is the provisions of the Constitution. The first, as we have already said, is Section 181 of the Constitution. The preamble to that section says, the following state institutions strengthen constitutional democracy in the Republic. And the first in line is the Public Protector's Office. We draw attention to that fact because we will ask the court that when you consider what are the powers of the Public Protector, you have to consider what is the purpose of that office. It is to strengthen democracy.
And then you've got to go back to Section 181.1, Section 181.3.
Yes.
And you've got to read 181.4.
Yes. I will get to those sections. But for the present purposes, the submission that I make, which appears on it to be elementary, is that when you look at the remedial powers of the Public Protector, when you consider her role of investigation, you have to do so understanding that the purpose of establishing that office under the Constitution is to strengthen democracy.
Mr. Malika, some of us are getting older.
Your voice drops every now and then, Mr.
I must apologize.
I am also struggling to hear.
It has been compromised.
So when my brother presiding refers to age, it's not necessarily on account of age. It's more likely because you're dropping your voice. Because not all of us are equally old.
I'll try and speak out. It has been compromised by matters beyond my control. Age does affect health, and I'm at the stage where my voice has been affected adversely. But I'll try and speak out as much as I can.
Yes, thank you.
I had made the submission that when you look at what constitutes remedial powers of the Public Protector, you have to do so in the context of the fact that that office is designed to promote democracy. And we would attempt to show the court that in the scheme of the allegations that she investigated.
So the others who have forgotten to switch them off, please do so now.
In the scheme of the allegations that were investigated by the Public Protector and the remedial action she directed that they must be taken, there is a fit between her report and the need to promote and strengthen democracy. Can I?
I'm sorry, just repeat that last part.
That the investigation in this case done by the Public Protector and her report and the way it ought to have been dealt with provide a fit between the purpose of strengthening her democracy and the remedial action she has directed.
So, sorry, can I just understand the argument? You started off by saying, in this case.
Yes.
So are we being case specific? Are we drifting away from the principle?
I'm making two propositions. One is a page 731. I believe it's volume 4. You will recall that in sequence, the report of the public protector comes in February 2014.
No,
and then on the...
Did you say page 73?
731.
Is it the middle 731 or?
It's the right hand...
left-hand corner?
The right-hand corner.
The left-hand corner.
Left hand. I'm working on a different record, of course.
But what is the document?
The document is a letter addressed by the DA Shadow Minister.
Yes.
Okay.
Yes. Okay.
Dated 10 July 2014.
No, that's fine. We have the document.
Indeed. And you'll see that there are a number of bullet points that she asks the portfolio committee to summon the minister to appear before it and explain a number of issues arising from the report of the public protector itself. I am not going to read them, merely ask the court to note that these are the matters contained in the report of the public protector. And the DA invites the relevant portfolio committee to summon the minister to explain those matters. Now, what happened?
And they said they had no response.
Well, it is not as if they had no response. One has to look.
Page 697, paragraph 39.
Justice Swen, I believe that you're referring to paragraph 39. Or
That's correct.
Yes.
Yes.
Can I make this submission with reference to that paragraph? What happened is that 5 days down the line, after this letter was written, the DA launches the proceedings in the court below. We submit that if an institution such as the DA, which is part and parcel of that national legislative body, triggers the legislative instruments to deal with the report of the public protector, it is not entitled to rush to court until one of the two things has happened. Either...
Well, are you saying that no response was necessary to this letter because the DA instituted legal proceedings?
They anticipated the outcome of the processes that they themselves engaged in. And
why was there no response to this letter?
Well, I don't know why there was no response.
Well, on the papers there was no response.
I'm even prepared for the purposes of the second point that I'm going to make. But let us assume that within that 5 days...
Yes, but then the letter you're referring us to has to be seen in that context. They made queries and there was no response.
Justice, I'm prepared to assume, for the purposes of my submission.
Yes, well, there's nothing else on the papers. There was no response.
But what is dealt with on paragraph 39 is not the date of the 10th of July, it's the committee meeting on the next day. It's the 11th of July.
Yes.
So it's that day plus the next day, and then they say, we've been blocked at every turn.
Well, let me accept that those are the facts, and then make the following submission.
Yes, all I'm saying to you is that the letter you're referring us to show that the DA understood what the public protector's report was about has to be seen in that context, does it not?
Yes, I'm prepared to accept that those are the facts, and that there is a context in which the letter has to be seen. On that approach, the rule of law, as we understand, requires the DA to do is to compel the committee itself to deal with the report, rather than to take away that power of the committee and Parliament and vest it in the court. As we understand, this court has always held that you have to go and discharge the functions and duties of a public body, and only when you tell us that that public body is unwilling, unable, or is refusing to discharge its function, will you come to us? I make this point because our constitutional democracy is not one of rule by lawyers, it's one of rule of law. In this case, you know as much as we do that the provisions of the Broadcasting Act tell us how these sorts of things must be dealt with. I'm not going to repeat the submissions that we have made in our heads, but I ask the court to consider the provisions of Section 15A of the Broadcasting Act. Our understanding is that Section 15A was not part and parcel of the original provisions of the Broadcasting Act. It was inserted in that act in 2009. And we would submit that that section was inserted in that act for a reason. And the reason is that when these sorts of matters arise and the public protector brings to the attention of the National Assembly these sorts of matters, then those provisions must be triggered. This court is in a more advantageous position because we know that the respondent in this case triggered those provisions. And so we would submit that on the facts, the DA did something which does not uphold the rule of law. The second point that I'd like to make on this score is this.
Does this point, I'm sorry, I'm trying to understand this. Does this point go to their standing?
No. It does not go to the standing. It goes to whether or not they were entitled to the order that they sought and got.
So they had standing to approach it?
Oh, yes. I don't challenge their standing at all.
Well, if they had standing, why would it not have been permissible for them to get an order?
Because they have to
made out the case?
They have to show not only on the facts, but also on the law that they're entitled to that order. And we submit that they're not entitled to that order. The second point that I'd like to make on that theme of the DA purporting to uphold a rule of law is when you look at the contents of the Public Protector's report, you will find that it is quite clear and deliberate in its own wording about the terms of the remedial action that ought to be taken. You will not find as part of the remedial action directed by the Public Protector the question of the immediate suspension of Mr. Motsoeneng. Obviously, those who represent him, they will make submissions on his behalf. But the simple point I'm making at this stage is this, that there was nothing in the report of the Public Protector that he ought to be immediately suspended.
Well, could I understand it? And just glance through your heads again, and it seems to me that the point you make essentially is this. It's for a minister to remove him, nobody else.
It is Parliament which has...
Yes, through the parliamentary process. No, that's the short and the long of your argument.
And the point we make there is unlike the DA who seems to misunderstand our submission. The minister has no discretion. Once Parliament adopts that resolution, she is obliged to act in terms of it.
But surely there must be an anterior position, isn't it? He should have been properly charged and found to have committed some act which would require him to be removed.
And
so the DA's letter couldn't have been there because nothing had happened before.
No. The DA's letter triggers Parliament's power to call upon Mr. Motsoeneng to explain himself. If necessary, Parliament can put charges to him, as it has done in respect of other public officials, hear him, and
Mr. Maleka, if you go back to your heads, if you go to paragraph 13, that's a process that's triggered through the board. That's the inquiry. That's what you rely on.
Paragraph 13 is section 15(1)A.
Yeah.
It is the process that is triggered by...
So that's right. That's what you got. That's a path to get rid of it. That's you saying. That's the only path.
No. If you look at paragraph 13, Justice, paragraph 17.
Yeah, but the two dovetail. I mean, you can't. You've got to have an anterior procedure before you get to Parliament. Isn't that correct?
No, we make in paragraph 17. The submission we make is that the normal rule, the rule which must be applied, is a section 15(a)(1) process. If there are exceptional circumstances, for instance, issues concerning the agency of the matter, you can rely on other processes.
Yeah, you're kicking it upwards, as it were.
Indeed. And the reason why we kick it upwards is because the legislation in this case tells us that that's the power of Parliament to do so in relation to directors of a board such as SABC. That is how the Broadcasting Act is formulated. We're not suggesting that you cannot take away that power. You can, as this court has done, but only if you show exceptional circumstances of the clearest cases.
No, but hang on, let's just work this out. It must be this, that if you, it's again, who's guarding the guards? If the guards themselves don't want to do it, because there's let's just, worst case scenario for you. Let's just say you have an obstructive board and an obstructive minister. I'm not saying that's the case here, just using it notionally. That's what you had. Surely you'd be able to say to a court, well, hang on, they're supposed to do X, Y, and Z. What they're not doing is, in the face of what they're doing, there's been prejudice to the institution. That would be a clear-cut case. But that would depend on the facts.
Indeed.
Right. Good.
And I mean, there are two...
Can I just raise this with you as well? I mean, isn't the DA's case slightly more nuanced than that? And that is, it begs a further anterior question, namely whether or not the man was properly appointed in the first place. And they seem to attack his appointment on inter alia on these grounds. They say the post wasn't advertised. They say there was no interviewing process. There were no other applicants. The item didn't appear on the agenda, and we're talking about the SABC board for that matter. And then, of course, there was the recommendation from the board that very night. It may well be that there was an interdict stood in the way as well, whether or not there was a settlement agreement, and whether that settlement agreement necessarily had the effect of the interdict falling away, I don't know. But they raise all of these points, and they say in those circumstances, the recommendation by the board is fatally flawed, and for the minister to have acted on that recommendation itself is tainted.
Yes. The nuances in that case makes it even worse for the following reasons. Firstly, when he was appointed permanently, he was in an acting capacity. So that when they challenge, and assuming they succeed on the appointment of Mr. Motswaneng as a permanent COO, that appointment will be set aside. But it doesn't follow that he would not be an acting COO until a permanent appointment arises. But the difficulty with the nuance is this. But it does not follow that simply because Mr. Motswaneng was appointed as a permanent CEO, you cannot convene disciplinary processes against him. You will. In this case, we know that on the approach of the DA and the way they have formulated the court order that they sought and got, is that not only do you suspend him entirely in any capacity as an employee of the SABC, you might, in due course, constitute an inquiry which finds him guilty and dismisses entirely as the employee of the SABC. And that's the difficulty of the order. But it seeks to conflate two types of separate offices that he held at one or other point. And so we would submit that the difficulty of the order is exactly the point, that it seeks to avoid even the rights and obligations of the SABC in relation to one of its employees in a different capacity.
Do you say that it was the minister who had the discretion to suspend Mr. Motswaneng?
Indeed.
Now, the DA says that given that she has so recently approved his appointment, that was not a real possibility.
Either the DA acts on its own fences and say that because the minister has taken one course of conduct, It is not going to trigger the provisions of the Act and invite him to do the right thing. And only if he fails, then they go to court.
But you say that that's not a reasonable inference to
No,
draw.
with respect, not. With
That's
respect,
appointed and permanent.
with respect, not. I remember there's a judgment of the High Court in
Mr. Maleka, where is it taking us? I mean,
Well-
you're saying at some stage you say, that's not to mean the minister won't do the right thing. I'm not quite sure whether that's an invitation. I mean, I'm not quite sure what that means. Is the minister intent on having the
Well,
inquiry?
The point is this, Justice Naps, is that before you take away the powers of the minister to suspend, invite her first to exercise or refuse to exercise.
But Minister Karim was told what she required of him.
Well, that's the point. And I heard the debate between my learned friend for the SABC and the court in that score. Let me accept, insofar as the issue of Minister Karim may be relevant for the purposes of this court pondering and making judgment. Let me assume that that is a vital matter of concern that the court will take into account. And Minister Karim or his successor in title does not act in terms of that undertaking. The rule of law requires someone who believes that there is wrongdoing to compel the minister to live up to that undertaking.
What, a mandamus?
Indeed, not to take away that power and say that the courts must then exercise it on his or her behalf. I have never come across the case where, as a matter of rule of law, the court says we take away the exercise of public power from an institution, unless the affected person says there are exceptional circumstances. I can indicate that in the course of our preparation, we came across two latest cases of this court. The one is the one that we gave Mr. Justice Nafsa in the Bangwanyama number 3, where you concluded that the matters were so bad that there was a clear case of bias that you cannot refer back exercise of public power.
That's always been the case, isn't it?
Indeed.
No, right. But in email from here, yeah. So when I umutena nje uzotena uyakubona so that ngizothola ama faces up singathola profile shot. Actually ngizo avoid ke.
Aisha, you're on. Aisha, I can hear
avoid
this now.
ukuthi ngiveze at the back. I will see what I can do.
Huh? Yes. Yeah, what? Hi. Ata no thaba busuke. Eh. O tla thaba busuke. Eh. A very good afternoon once again to Elvis, and a very good afternoon once again to our viewers at home. Indeed, the mood is still as high as it was earlier on in the morning, although the songs have started to fade away a little bit. You'd recall that most of the people attending the court proceedings here outside, friends of Hlaudi Motsoeneng and the general supporters of Motsoeneng, gathered here as early as midnight, some as early as 6 o'clock in the morning. So one can say that they are, slowly but surely getting tired, but eagerly awaiting to hear the proceedings inside the court. I must also indicate that just a moment away, the SABC lawyer was arguing that the public protector had recommended that Motsoeneng be investigated, not necessarily suspended. That's the argument currently taking on. So we are yet to hear what the legal representative of the communication minister is yet to say, as well as the legal representative of Hlaudi Motsoeneng himself. So that's basically what is happening now. But for me, outside here, we do have supporters of Hlaudi Motsoeneng who came as far away as KwaZulu-Natal, some of them as far as Gauteng, the different provinces across the country. Kindly tell us where you're from and why you're here.
I'm from KwaZulu-Natal, the province that is led by Senzo Mchunu. I'm here in support of Comrade Hlaudi, knowing very well that issues that we are dealt with are supposed to be issues that should be dealt with in labor courts. Firstly, you can't deal with issues of an employer and an employee in such courts. And we suspect, obviously, we know it is not just, it involves politics. Look at the work that has been done by Mlaut and SABC. Look at the improvements that has been done. Out of these 20 years, why today we have to deal with Mlaut like this? So that's why I'm here in support, and I'm expecting that the court will just take the matter to the labor courts, and labor issues will be dealt in such level.
Well, thank you very much. He's basically saying that this is politically motivated itself. He's saying that this is an issue that's supposed to be an employer and employee. Let us just hear one more person who's here today. Where are you from?
No, thanks. I'm from Limpopo, from the province that is led by Comrade Stanley Matawate. We are here in support of one of our own comrades, comrades Hlaudi Motsoeneng, who is being in charge of SABC. Since he was in charge in SABC for the past 20 years, we never had anything with regard to the issue SABC being built out because the SABC is running out of finance. But we are saying that the leadership under Hlaudi Motsoeneng was improving, and it was also showing that indeed under his leadership the Rainbow Nation will be built and the people of South Africa will be united, and we are going to build the Rainbow Nation in achieving our struggle of national democratic society.
We're not necessarily going to know the outcome today, but what are your expectations from the appeals court today?
No, we are expecting that the rule of law must take its course, but we are saying that we are in defense of Hlaudi Motsoeneng because we believe that Hlaudi Motsoeneng, the issue of him not having qualifications, but we agree that if he has qualifications but is qualifying and is leading with skills and utmost experience of leading that particular institutions of society, we are saying that the court must take a justice and must make sure that that SABC is being under the administration of Hlaudi Motsoeneng.
Well, thank you very much. One supporter of Hlaudi Motsoeneng all the way from Limpopo. With me here is a lady from Gauteng, right?
Yes.
Why are you here?
I'm here to support Comrade Hlaudi Motsoeneng. I'm asking myself, as my brother has said, I'm going to add on what he has said, that why now, after 20 years, that he must be removed from his position because of his qualifications? Because we believe that him being in charge, it has never degraded the standard of SABC. Instead, the standard has been uplifted. That's what we see as people. You know, we see new series, new dramas. A lot of things have changed. Even right now, as he has been demoted or he has been suspended. So, as it is said, what we see is that you will see some intervals when there's dramas or comedies playing. You will see some intervals. SABC will say we're coming up shortly, and we don't understand, is it because he's suspended or what? So we know that he has been leading and with very good skills, and as my brother said.
Thank you very much indeed. Sharing the same sentiment, saying that Hlaudi Motsoeneng has been leading the corporation to the best of its ability. So you're also from Gauteng, but you know the main question is, why are you here?
Yeah. I'm here to support Mr. Motsoeneng precisely because right now he has done so well in his post and he's doing a good job. The SABC is improving, and why are we attacking him on the issue of his qualifications? And he has the skill, he has the expertise. So why is that an issue? But while we are seeing the results, what we are saying today is that hands off, put the man in his position, in his post, and let him continue to do the good work that he's doing.
Well, that's the main message here by the supporters, saying hands off Hlaudi Motsoeneng. That's basically what is happening. Like I said earlier on, there isn't much happening in terms of songs right now, as everyone is eagerly awaiting to hear what has been going on inside the court. We do have our reporter inside the court who will be giving us an update later on. But now, it's back to you, Elvis.
I don't know how to open it.
Yes.
I've obviously had the benefit of listening to the exchange between the court and my colleagues. So I do not intend to traverse ground that's been covered. But if I may just add my view on what is the best way forward. Very clearly, the practical and the best way forward is for the review to be heard as soon as possible. In fact, when the court will recall because it was added to the record at the instance of the DA. There was an attempt to ask the court to enforce the suspension order and the disciplinary order. Yes. That then wasn't heard when His Lordship, Mr. Justice Desai presided, then facilitated a meeting in his chambers, and we ended up writing a letter to the registrar of this court, and that is why we are here today. And we thought that even at that stage, the offer had been made to the DA that let us concentrate on getting the review out of the way, and all these issues would be resolved. So unfortunately, we are here, and my focus is to address the court on the issue of the suspension of Mr. Motswaneng. Now, firstly, what is obvious is that the public protector, whom we all hold in very high regard, the profile that she's given to that office, everybody talks about it, and I don't doubt in this room and outside of this court that everyone takes what she says seriously. That she, in her wisdom, having investigated the matter, having reported on the matter, and having taken remedial action, all the 1A2, 1ABC stuff, did not deem it appropriate, necessary, or desirable that Mr. Motswaneng be suspended. Now, the question then is this: what right did the DA have to approach the High Court in Cape Town to seek his suspension and to ask that disciplinary proceedings be instituted against Mr. Motswaneng by the SABC? I want to take the court to the starting point, which is in the founding affidavit. The DA does not assert any right or any basis on which they request or demand, rather, his suspension, other than to say he's a bad guy. He threatens freedom of expression, and the allegations in that regard are quite hysterical and paranoid, that if you do not remove Mr. Motswaneng, then the freedom of expression is under threat. The SABC is going to collapse. Of course, with the benefit of hindsight, we know that that hasn't happened at all.
Well, we have nothing to tell us what the current state is before us on record, Mr. I mean, I just don't think we can go there.
So no, I would agree that we not go there at all. But if we look at the founding papers in the court a quo, then we see that the DA themselves, Mr. Self, doesn't say that they have a clear right to ask the court for his suspension. What he does, and it's addressed much later on in his affidavit, is he says,
where are you, Mr.
in volume 1 on page 39, at paragraph 91 under urgency, he says the matter is urgent as a result of two factors. 91.1, the serious harm that Motswaneng has done, not to the DA, to the SABC, and that he will continue to cause for as long as he occupies the position of CEO. And 2, the need to vindicate the constitutional role of the public protector. Then they highlight the findings, and then on page 41, paragraph 98, he says the DA has a clear right to the relief sought in Part B. For the reasons explained below, the appointment of Motswaneng was plainly irrational and unlawful. Now, I was listening earlier on this morning about the low threshold and so on, that Well, that then brings me, or I will engage on that issue. That then brings me on what basis the High Court finds a right to suspend Mr. Motsoeneng. The High Court is wrong because it has applied the wrong test. Firstly, in evaluating the facts before it, and secondly, by not applying at all the test that is now laid down in National Treasury and OTA in that case. That case is very clear. Not only must a litigant have a right to review administrative action, a litigant must actually demonstrate irreparable harm if an interdict is not granted pending the review. Now, in this case, I've just read to your ladyship the passages. The DA does not say that they are going to be caused irreparable harm if Mr. Motsoeneng is not suspended. They say if he's not suspended, in fact, they want him removed. That is why.
No, but you say, I mean, isn't that the wrong image that you're conjuring up? I think that the image there, certainly my reading of the papers is, they say, listen, this man has no integrity. He's advanced himself. He's advanced lackeys. He's done all sorts of other things. He's given himself a massive increase. He's done X, Y, and Z. Look at how he got the job. Look at where it's all gone. That's why there'll be irreparable harm. Not in relation to the DA, in relation to the institution. That's what they say. Now, I'm not quite sure that I understand why that's not the picture that they paint. You don't have to agree with it, but that is, as I understand it, is the picture.
Of course we don't agree with it, because that picture was painted already in November 2013 when the preliminary report was issued. It was then painted in February 2014 when the final report was issued.
But that takes me back to what my sister Dambuza brought. Take 95, take what the DA says is what you're dealing with. My sister Dambuza says, go look at what the court said in relation to its assertions, and why should we upset that?
This court should upset it because the court below did not apply the proper test, whether it is on an interim interdict basis or applying the Plascon-Evans rule when it comes to final relief in motion proceedings.
Mr. Arendse, you've been to court several times, particularly in the Battles case, on interim basis, several times. And on the interim basis, it's mainly a holding exercise. That's what you're dealing with. You're saying, well, you know, I can't prove my case conclusively, but I'm giving you a basis. Basis may be open to some doubt, but there is a basis. And then you go to the next phase. Now, that doesn't mean you can make conclusive findings. It's I mean, Justice Skippers did sort of got a bit confused between the final and the interim. But that aside, why on an interim basis can't you at least put down the basis of a case that's not so flimsy that it can be rejected? There's no prima facie case, if there's no case open to some doubt, and if you don't grant it, there'll be irreparable harm and the balance of convenience favors you. That's as I understand the test. But
with respect, the test is laid down in the National Treasury case. Let me read it to the court. At paragraph 30. Under Setlogello test, the prima facie right a claimant must establish is not merely the right to approach a court in order to review administrative action. It is a right to which, if not protected by an interdict, irreparable harm would ensue. An interdict is meant to prevent future conduct and not decisions already made. Quite apart from the right to review and set aside the impugned decisions, the applicant should have demonstrated a prima facie right that is threatened by an impending or imminent irreparable harm. The right to review the impugned decisions did not require any reservation pendente lite.
So it is not a right that has to show that particular
that is why, my lady, we, in our heads of argument, had said that the DA does not and did not have locus standi to approach the court for this kind of relief for his suspension. We have no quibble, and of course there's been several cases in this court that they do have a right to review administrative action unlawfully or unconstitutionally taken, and that is part B.
Could we just return to the dictum you read to us? The only point to be debated in relation to that dictum is whether the facts come within will provide the basis. It's no more, no less than that. I mean, what that case says is what Setlogelo says, what any other case says about interdicts. And then you have the interim interdict situation. They've got to do it, as I understood your heads, and tell me if I'm wrong, as I understood your heads, you said none of this has any basis. That's as I understood your heads. None of the factual allegations made by the DA have any basis. That was your onslaught against the DA's charge. You said that's nonsense. There is no basis for any of this.
There's no basis for the suspension, yes.
There's no basis for the interdict.
And neither did the public protector think that there was any basis for a suspension, yes, because
but things have moved on since then. I mean, the public protector thought disciplinary action was appropriate. If disciplinary action had been taken, well, we wouldn't be sitting here. But disciplinary action, not only had disciplinary action not been taken, but lo and behold, the man was then appointed permanently in the face of that report and in the face of her findings.
But that
so it's against that backdrop. It moves on from the findings of the public protector. It's against the further conduct, namely his permanent appointment, that it became necessary for the application to be launched.
Well, if your lordship, Conan, is prepared to move on from the papers, then let's move on from the papers.
No, sorry, I'm not moving on from the papers.
From events that have unfolded subsequently.
No, I'm dealing with what's full square on the record. I haven't made reference to anything that is not on the record. I am saying to you, it started with the public protector's report. There is the report which says, you SABC board, you've got to take disciplinary action against this man. They don't. Not only do they not take disciplinary action, they then have a meeting at which he is recommended to be appointed permanently to the post in which he had previously been acting. And it is against that backdrop that an application to court is then launched.
So it's not post the litigation, Mr. Arnoldson.
But with respect, Justice Ponan, that is all the stuff of Part B. It may well be justified in the review application. Does that justify him being suspended? That is the question.
But I understand what you're saying, Mr. Arnoldson.
I'm very happy to hear that.
I've got no difficulty with the position you adopt in your heads, that there's no basis for an interdict.
Yes.
That's the position you adopt. No one's asking you to retreat from. You're saying they shouldn't get an interdict at all. Well, then it's a question of what we make of whether or not applying the dictum you referred us to, whether there was such a basis or not. It's one way or the other.
So if I may just summarize then what's in our heads.
Yeah.
Firstly, the basis for not upholding the order of the court below on the suspension issue is that the proper test wasn't applied. Secondly, there's the issue of which relates to the separation of powers. Is that Mr. Motswaneng has a contract with the SABC. That contract includes his employment rights to fair labor practices. The personnel regulation is before the court. Suspension requires a hearing before that decision is taken. Then he's got his constitutional rights, which is now enshrined in the LRA, which says, well, if you're still unhappy with your suspension, you can go to the CCMA and declare an unfair labor practice. Now, he's denied of all these rights. In fact, this case was brought urgently in July. The matter was heard in August. The decision was then given sometime in September. And when the judge returns and he summarily just says, you are now suspended. With respect, that's outrageous.
can I just say this? That I think that part of the problem is, and I've had difficulty understanding part of the judge below's judgment, turning it into a final decision. And the conclusion that he arrives at, as my brother Swain and my brother presiding and everybody else pointed out, is that it preempts what is to happen in Part B. And that's what we've been trying to debate with Council up until now. So I understand that. It's just a question of how one deals with it.
Yes, in fact, the judge deals with Part B and then comes back to Part A. He goes to Part B, and for example, Mr. Justice Ponen and your Ladyship Dambuza, as you point out, not only don't they hold a disciplinary inquiry, they appoint the man. So he goes to that and he says that appointment, which is the state of Part B, is unlawful and unconstitutional. Then he comes back and he's clearly unhappy with the appointment. And he says he's a bad guy, now he needs to be removed from the workplace. There's no logic in that. And that's the problem with the suspension order. There is no logic in it. All the complaints with respect.
Could I just ask you, when you started your address, you suggested that you might have some wisdom we could benefit from, and it was this. You suggested that what needs to be found is a practical way to deal with the matter. Now, do you have a suggestion for us?
Well, the practical way forward is that the review must proceed. It's set down, and I think it's going to be before a full bench. And that matter will proceed. It's a few weeks down the road.
What do we then do with the order of the High Court? Are you saying we've got to set aside the entire order?
Well, you can either suspend the order, pending the outcome of the review. It may or may not. You may find subsequently that it was justified. Alternatively, these proceedings can be postponed.
Can I just raise this with you? If in fact the SABC board had acted pursuant to the report of the public protector, and if they had timeously, as she had prescribed, taken the necessary disciplinary steps in respect of your client, would that have been worse for him than a suspension now?
No, that would be entirely what remedial had proposed by the public protector.
Is a suspension now more prejudicial than if they had acted timeously and properly?
We've cited the case of Mala, and there's a whole host of cases in our labour law which...
I understand the principles, I'm dealing with the facts. On the facts of this case, if the employer had acted timeously, properly, in terms of the report of the public protector, and had instituted disciplinary steps against your client, would he necessarily have been in a worse or better position now when one is facing a suspension, absent the disciplinary steps?
He would be in a position where he could have no complaint. If his employer said, I am going to abide the remedial action that is being proposed by the public protector, I'm going to institute a disciplinary inquiry. That is why we say, in this regard, the rights of the employer had been taken away summarily, arbitrarily, and irrationally by the court below, because one of the things that one would consider once disciplinary action is instituted is whether the accused will be permitted or be allowed to be around in the workplace.
But could I just understand this? Other than the DA, who seems to want a decisive
And that is exactly what the outer case is about. This does not affect. That is the difficulty all of us had. There is no relation. There's no relationship between the Part A relief and the Part B relief.
Let's just try and untangle it for a moment. Let's just say, well, let's go back notionally. Notionally, the parties could have said, when they appeared before Justice Schippers, they could have said, look, we accept that there should be a review. Let's just go through it and let's run. So you can order that a review, or we'll just have the papers then stand and then we'll have them supplemented a la the old Rule 53. I mean, classically Rule 53. Parties could have done that, notionally.
We in fact, far down the road, it's all been done. All the papers are in.
No, what I'm saying is, right at the beginning, when the matter was due to be debated before Justice Schippers, parties could have said, let's just skip Part 1, we'll go to Part 2.
That was proposed by us.
Okay. Do you agree that the issue of public protectors' powers and the extent to which they have to be obeyed will only arise if, after the review, it's found that your client should not be removed from office? In other words, disciplinary proceedings will only become an issue if, after the review, the outcome is no, your client shouldn't be removed from his office.
Yes.
So in other words, all of that debate about the public protector's powers is premature until such time as the determination is made as on the reviews whether your client can stay in office or not.
Absolutely, because the irony is, and in this regard, we would support the submission, because if the public protector's powers are legally binding, then there was no basis for the court to interfere and to add on the suspension, as it were. Then it was simply a case of saying, no, you are bound, I'm ordering you to hold a disciplinary inquiry.
Well,
which it could have done.
The reality of this case is we're dealing with suspension, we're dealing with disciplinary proceedings, and we're dealing with removal from office. The third leg will be determined by the review. You're arguing about the suspension.
Yes.
Disciplinary proceedings are dependent upon the outcome of the review.
That's correct.
The issue of the public protector's powers is inextricably linked and only has to be determined in regard to disciplinary proceedings, because that's the recommendation she made.
Yes.
And that is the issue as to whether that recommendation is binding or not.
Yes.
So those issues only arise once the outcome of the review is determined.
With respect, that would be correct.
You would only be concerned today with the issue of the suspension.
Yes, and our submission in conclusion is we argued or contended that the DA was seeking final relief in Part A. In reply, they denied it. They now accept it. The judge said you are seeking final relief. But then the question is, what test does he apply? Doesn't apply the Plascon-Evans test, because that's always been the difficulty for the DA and Mr. Self. Their cases made on the basis of a report, the contents of which there's no agreement. As much as we respect the public protector, there's no agreement that the contents of the report are correct. In fact, we challenge that, and she then only files an affidavit because those contents are now being challenged. But I think quite wisely she doesn't take issue with us, with due respect to her office, and that will be dealt with in the reviews. So on the Plascon-Evans test, and if the judge says it's final relief, then he hasn't applied that test. And one can just look at the test as formulated very succinctly by Deputy President then Harms in the Zuma NDPP case.
If sorry, when you finished with
and if it's for interim relief, then we know it is a no-brainer that there's no right to be protected pending the review. The review is a standalone and is apart from Part A. So there's no basis either way for the suspension order.
Can I just establish this for you? You see, in respect of Mr. Motswane, one is dealing with two different types of employment scenarios. The one is he was in the position of an acting COO at the time that the public protector investigated and filed her report. And that pertains to his suitability in relation to that position.
Yes.
And then events move on, because then he's appointed permanent CEO. Along comes the DA, and they say, well, there should have been a disciplinary inquiry in relation to his conduct as it then stood, namely, whilst he was still the acting CEO. Seems to me that that is the relief that was sought under Part A. Then you've got Part B, because they say, well, things have now moved on since the Public Protector's report. He's now been appointed permanently. That decision is irrational, unlawful, call it what you will, and that falls to be set aside in Part B. So it's two, in a sense, distinct relief that is sought in respect of the different types of scenarios that one is dealing with. One, pre the Public Protector's report and up until the Public Protector has filed a report, and post the Public Protector's report. Up until she files her report, that seems to be covered under Part A. After she files her report and the events that unfold thereafter, his being appointed permanently, that seems to be the relief that they want under Part B. But we still have to deal, I would imagine, with the powers of the Public Protector insofar as Part A is concerned. Or would I be wrong?
Well, the problem for this court is that none of the grounds of appeal relate to the powers of the Public Protector. The DA and the other respondents, including ourselves, were in agreement with the judge that the Public Protector's powers are not legally binding. Obviously,
were you also in agreement that her, and I want to call it directions, could not be ignored?
Absolutely.
You were in agreement with
absolutely. It is correct that I think it was it's under 183 that the public institution, the public entities have a duty to assist and to protect and to aid the Public Protector in dealing with issues of corruption and malfeasance and so on.
So why were they not entitled under Part A to come to court and say, the Public Protector directed that you have a disciplinary inquiry, you haven't done so. Court, we now want you to issue an order directing the SABC board to have a disciplinary inquiry and pending that for him to be suspended.
Well, then
isn't that really what Part A deals with?
That will deal with the disciplinary inquiry, and one can see the sense with respect of the Public Protector saying, have the disciplinary inquiry, because what the Public Protector does not say in a report, you can perhaps infer it from a report, but the Public Protector does not say that Mr. Motsoneng is not a suitable candidate to be appointed as COO.
Well, if she did
what
that,
she says,
if she did that, what would be the point of the disciplinary inquiry?
No, she says that a disciplinary inquiry must be conducted into a whole range of allegations. Now, if he is cleared in a disciplinary inquiry of all those allegations, what stops him from being appointed or from being a candidate for appointment as COO? There's nothing. That is why I'm saying she must have thought it through. That is why she did not recommend a suspension pending the disciplinary inquiry, because the disciplinary inquiry would also be an opportunity for Mr. Motsoneng to clear his name.
Yes, but she envisaged the disciplinary inquiry would take place within 60 days.
Yes, and she envisaged the disciplinary inquiry to take place whilst he was acting COO.
Did that happen?
Well, it didn't happen, but thankfully I'm not here to answer for that decision.
Well, could we just go to the order that Justice Kippers made? Because, I mean, I think that part of the problem is it all got muddled. And if you look at para 127, in which he sets out the order and he categorizes what should be the subject of the inquiry, the board of the SABC shall within 14 days commence by way of serving him notice of charges, disciplinary proceedings. And this, again, is the kitchen sink, I think. for his alleged dishonesty relating to the alleged misrepresentation, proper inconduct in the appointment and salary increases, for his role in the alleged suspension and dismissal of senior members of staff, resulting in laborious settlements towards the SABC referred to in respect of the public protector. Now, if you start about his qualifications, the qualifications part ties in with his appointment at source, with his continued competence to hold office, because it's an integrity issue.
Yes.
So it crosses over onto that. And then his abuse of power in relation to what he did whilst he was at the SABC in appointing himself and increasing his own salary. Those are all part of the public protector's, a report encompasses all of that. That's correct, isn't it?
Well, and for the purposes of for the final relief relating to the suspension, the judge could only, he didn't, but he could only apply the Plascon-Evans test. Now, whether we like it or not, the SABC's response in relation to the abuse of power, the increase of salaries and so on, is comprehensive and is not, and it cannot be controverted by the DA or Mr. Self at all. So on what basis does the judge just say, look, I am ignoring everything else, the public protector, what she found, those are the facts. And that's with respect why the public protector wisely said, now take these allegations, they are serious. They raise matters of serious concern about the integrity of the individual, the integrity of the institution, for the rule of law in our democracy. That must go to a DC.
Well, I'm just trying to...
But that's not the basis with respect, Judge Nefza.
The debate at the moment, because it seems to me that if you look at what was envisaged by way of the disciplinary inquiry, it relates to both, it relates to pre-report activities, and it encompasses report activities. What then would part B deal with? Of what would the review deal with? Would the review also be concerned with his appointment? It seems to me that was what was envisaged.
Well, it will relate to his permanent appointment.
It would relate to his permanent appointment, and it would relate to his, importantly, that's where the public protector's report will come in, his suitability to be appointed. And how do you determine his suitability?
So theoretically, one could end up with a situation where, for example, a court may find that is in due course, that his permanent appointment was improper for some or other reason and set it aside. But he will continue to act as the COO. And then, of course, the question arises whether or not he's suitable for that position. And that's where the public protector's report looms large. And that's where questions arise as to whether or not there should be a disciplinary inquiry in relation to his conduct there. Does it not?
Absolutely, because
yes.
His appointment on the 8th of July may well be set aside for legal technical reasons. Authority, competence, and so on. But it may not go to the issue of whether he is a suitable person to be appointed to that position. We can't have someone...
But it may cut across both, and that's part of the problem, and that's part of what wasn't thought through. So if it finds that he's a person of no integrity, it will then cut across both. It will cut across both legs.
Yeah.
Because then he couldn't be suitable, couldn't be the acting COO.
Well, I mean, if there's a finding that he's not a suitable person...
I'm putting it notionally, I'm not
yes,
putting it...
if there's such a finding, then it would be irrational for him to be appointed as an acting COO, even though his permanent appointment has now been set aside. Now we've never been averse to a disciplinary inquiry because it's important for Mr. Motsoneng to clear his name. But that is not the decision.
So let me just understand this thing. Because you're at the center of all of this. As I understood, Mr. Maneche, and he was very concerned about what your rights what you might have to say about your rights and not having to make decisions by the board that cut across your rights. So let's just say this. You seem to be in agreement that there shouldn't be any, there wasn't any disagreement about the public protector's report not being ignored. Would it be contrary, I mean, from what you're saying now, if we didn't go along with Judge Skipper's order that there be a suspension, but we ordered the disciplinary inquiry, how would that relate to Part B, or should it be subsumed by Part B? Or would you abide the disciplinary inquiry being conducted? Because you say you're not averse to it. And Mr. Katz now, for the first time, seems to be in agreement. So let's see if we can get there. And since he's in agreement, don't you be in disagreement just because of it. So let's just figure out where we go. Because trying to figure out where we go with you saying, well, you're not averse to the disciplinary process. You don't want the suspension to be upheld. Because you say, even though it might be implicit, she really wanted the disciplinary inquiry. We're in any event 1 month away from, less than a month away from the Part B. So let's see if you can help us, Mr. Aronson, because you did try to offer some wisdom. If you're not averse to the disciplinary inquiry, then shouldn't we just abide that so that, which would be in accordance with what the public protector has said should occur? And then, if the DA is willing to abide that may in fact negate the need for the review. Alternatively, you put this aside and you go for the review. I think those are the issues.
I think before I give a definite answer, what I will have to discuss with my client, because he wants his name to be cleared. He's never ever applied for a job. Won't surprise you. He's never applied for a job at the SABC. He was appointed as a low-level employee in 1995. Now we're talking about allegations of 20 years old. Now subsequent to that, he was promoted, and subsequent to that, he was in fact dismissed. So there was a break in the employment relationship. And that was in 2006, and he was reappointed by Advocate Dali Mpofu. So all that has been lost in this whole debate, and yes. So the other issues have been dealt with. I certainly would urge him to abide the disciplinary proceedings and to stand his ground and to deal with these allegations. Well, and those allegations, I think, if the disciplinary inquiry is then ordered, that the review should be postponed because it affects crucially.
Might I suggest the following to you? Because I think it will preserve everybody's integrity. I don't know what Mr. Marcus will say, but since the public protector in any event recommended a disciplinary inquiry, it would seem to me that would then keep her intact, it would keep you intact, SABC would be protected, and the minister would then not have the concerns about the separation of powers. So it seems to me perhaps.
We're going to take the adjournment now, but I would like you to just carry on with that, yes. and then we can say, let's take an adjournment and give you an opportunity to.
Okay. Sorry. So it seems to me that that's the best outcome for everybody. We don't get involved in the deeper philosophical questions because we all agree that she can't be ignored. The fight about what it means ultimately and when challenges can come can be for another day between different parties. Your client wants his day in court, in the disciplinary inquiry, he wants his name to be cleared, wants to hold it high. That's the middle ground. And I can't see why it would not be, why the other two, the first two appellants would not be amenable to it. And I think Mr. Katz, for once, said he seems to, and I don't know that he could get more than the disciplinary inquiry, because that is what the public protector wanted. So if we're all at idem, we can walk out here and everybody can feel a little better about themselves. That's all I'm putting to you, Mr. Aronson.
Well, perhaps this would
I suppose what you really would want is that the part about the suspension, that's the part that is of concern to us. We are prepared to go on with regard to the disciplinary part.
Yes, and if they, we know as a matter of fact that everybody has lived with Mr. Motswaneng since the report came out in February, since the court case and all that. There's no reason why they can't live with him for another, however long the disciplinary inquiry is going to take.
Let me put a negative to you for the other side. Let me put a negative to you for Mr. Katz and for Mr. Marcus. And it's this. There's a month to go before the review. So if you go down that route, it's just a month. The public protector wanted the disciplinary process. Let's go through it. That's what you wanted. That's what we'll abide. We'll all get through it. So let's see how we go. If you need to, perhaps with my brother presiding leave.
In fact, we are about. I'm going to suggest an adjournment, the luncheon adjournment.
As you wish.
And I think that should be an opportunity for everybody to be able to take instructions and with regard, particularly to what has been like a suggestion.
Yes.
From the side of the bench.
We've also got the important matter of rugby coming up, so we've got to focus on important.
Okay. But is it a convenient stage for you that we take the adjournment? What time will it come? 2:45. Let's make it 2. Yes.
Shall we adjourn till 2 or?
Till 2. So the court will adjourn until 2 o'clock.